can't gag the press. So far as they do a good job and they don't misinform or disinform, we don't have any authority to gag them. The only guidelines are make sure what your reportage is the truth. The press can come to report our cases or come to do anything with the judiciary. We are not sacrosanct. They can come and do that. We don't have the power to stop them, but just make sure that what you are reporting or your reportage is the truth and it's fair. And then as much as possible, do follow-ups before you come out. If you don't understand anything, ask. Don't report on perceptions. Please, Mr. Chairman, don't forget the judiciary is different from the judicial service. But a lot of people mix these things up. Things happen in the judicial service are attributed to the judiciary. We are two different arms, but working together. Thank you.
Yes, any further question? Very well. Thank you.
Honorable Mayor, you are entitled to 3 questions. It's different from the constitutional legal. No, you are a bona fide member of the committee.
Very well. Then I have other questions for you, my lord.
Honourable members, regarding Anthony Imie, I never said you are entitled to 1 question.
I am very grateful.
That is why I am asking you, do you have any further questions? And you said, no, you don't have a further question. So if you have a further question,
I have 2 more.
Just proceed to ask.
Thank you very much, Mr. Chairman. Now, nominee, Yao Opong, who is Justice of the Court of Appeal and an authority on constitutional law, has suggested that it was unconstitutional when the Dzamefe Commission released a white paper prior to the release of a full report covering, it's reported in My Joy Online. Prior to the release of a full paper, yes, a full paper on the 2015 World Cup inquiry. Now my question is, how would you respond to such a suggestion that the release of a white paper prior to the release of a full report is a violation of the 1992 Constitution?
Thank you, Mr. Chairman. I don't think the commissioner has the power to release white paper, but anyway, we made recommendations to government. After the commission, we wrote our report and made recommendations and presented the recommendations to government. That was all we did. We never issued any paper, sir. Thank you.
Thank you very much.
Thank you. Now a follow-up question.
A follow-up question on the white paper. Very well.
Do you suppose that the agency of accountability should justify the violation of a constitutional provision?
Well, permit me to treat this as a full question, not a follow-up. So, Honourable Nominee, you have the floor.
Mr. Chairman, anything that violates the Constitution is illegal. Whatever it is, once it violates or flouts the Constitution, it's illegal. Thank you.
Yes, you are done. Thank you very much. I would proceed to give the floor to Honourable Bid Azidin. Honourable Bid Sidin. Awantanzuma, you have the floor.
Thank you very much, Mr. Chairman. I'm happy that you have corrected yourself in the pronunciation of my name. It has taken me to be a Frafra man. I'm a Dagat man. We don't start our names with A. Leader, why are you surprised? Anyway.
Please, your question.
My Lord, congratulations for the nomination.
Thank you.
I think it's long overdue. You have been on the bench since 2000. And You have stayed there as a High Court judge until you were elevated to Court of Appeal judge. You have been in this business long enough. Fortunately, you are not one of the judges that is coming from outside the judiciary. Yes, I'm just building something. So, my Lord, in your judgments and doing interpretation, what are some of the rules of the interpretation that you have applied as a judge? Thank you.
Thank you, Mr. Chairman.
Honorable nominee.
Thank you, Mr. Chairman. Interpretation. The basic rule, the first rule is the literal meaning of the words. The literal meaning of the words. Number two, if the words create an absurdity, then you go to the next step, which is the golden rule. You ask yourself, what does the law seek to achieve? Then you interpret it to achieve the purpose. Then the third is, what does the law seek to prevent? That is the mischief rule. Then you interpret it as such. Then you go further. We have one we call the usdem generis, things of the same kind. So you know what to do there. And then there is one that tells you how you use words around a word to interpret that word. So these are some of the rules of interpretation we follow. Thank you.
Thank you very much. Yes, Honorable Bate Zedin, Ranking Member, Judiciary.
Thank you very much.
Have a further question?
I have no follow-up question, but I want to go to my second question.
Very well. Please do.
I just want to say that His Lordship's answer represents, I believe, a most excellent education on the rules of interpretation. Maybe TikTok will just take a bit of it and spread so that law students will benefit from this.
Thank you.
Very well, Mr. Chairman. My Lord, what innovation would you bring on board to improve justice delivery in this country?
Mr. Chairman, let me finish. Let me finish.
Give me the opportunity.
Okay, when you finish, I would come in.
Honorable Zedin, I believe this question has been asked and answered. The question has been asked and answered by another person. The previous questioner has asked a similar question, and my Lord has provided answers to the question.
Very well.
Wait, Honorable Bate. You know, the question you asked, which Chairman says has been already asked, the language, the same words, phrases, are you all coming from the same source of tutorials?
Nobody, don't answer that. Nobody has been giving tutorial in these matters. So please proceed to ask if you have another question.
Mr. Chairman, indeed, there's absolutely nothing wrong with we thinking alike, because we are individuals, but we can think alike. There's nothing wrong with that.
Further question?
Yes. Mr. Chairman, I only want to congratulate my Lord again, because fortunately for me, I appeared before him whilst he was High Court judge at Swedro, and I saw that he was a very fair-minded judge.
Thank you. Thank you very much.
Yes, Honorable John Darko. One question and a follow-up, if any.
All right, thank you very much, Mr. Chairman. Coming from the interpretation aspect, Mr. Nominee, if you read Article 66(2), it says that a person shall not be elected to hold office as President of Ghana for more than 2 terms. Do you think that this provision is subject to interpretation?
Mr. Chairman,
Honorable nominee.
the honorable member quoted from the Constitution, and that's what the Constitution says, so I can't have anything against what is in the Constitution. Thank you.
Yes, a follow-up question on the interpretation of Article 66.
Mr. Nominee, so if somebody says that a president of Ghana can serve more than 2 terms, except that it shouldn't be consecutive, what would be your answer to that person?
Honorable Chairman, the answer to that question is what the Constitution says. Thank you.
All right, thank you, Mr. Chairman.
Thank you very much. I'll proceed to give the floor to Honorable Alhaji Omar. You have the floor.
Thank you, Mr. Chairman and Speaker. My Lordship, congratulations.
Thank you.
I want to go into your rulings and opinions in your previous judgment. And it has to do with your position of the law regarding property owned by couples in divorce or death. What is your position? Thank you.
Thank you, Mr. Chairman. Our Constitution guarantees that every citizen can have property on his own or her own, and then in association with others. So I'll first go to on death. When a spouse dies, PNGC law 111 comes in to take care of those who are alive. Then when it comes to a will, if a spouse dies intestate, that's he hasn't written a will, then like I said earlier, PNDC law 111 comes in. If there's a will, we go according to the will. But then, if no reasonable allocations are made to the surviving spouse, the court will interfere. We'll go into the will and give something reasonable to the surviving spouse. Then what
do you mean intervention or interfere? Do you mean the court would intervene? Sorry.
When it comes to wills, we are not supposed to. Is it the word interfere or intervention?
What I'm asking is, do you mean the court intervening or you mean interfere? You said the court will interfere. I'm asking whether you mean intervene.
I will still use the word interfere because when it comes to wills, we are not supposed to. We interpret as much as the person making it wants it to. And so, Mr. Chairman, to continue, when it comes to divorce, if the property is jointly acquired, both parties have reasonable access to that property. And that's how the court looks at it. But then, a new decision now goes to say that if we must look at all cases on their merits. Recently, Najee says that, well, it's not automatic. You look at the circumstances. For example, if the property is jointly acquired, fine. But if it's not jointly acquired, maybe I took a loan for it as Najee, the court will not regard it as jointly acquired property. So the sharing will be different. But on the whole, when there's divorce, the court will make sure that a reasonable or equitable size of a property is given to the divorced spouse. Thank you.
Thank you. Any further question? Thank you very much. Honorable Patrick Yaboma, the floor is now yours.
Thank you very much, Chairman, and congratulations, my Lord.
Thank you, sir.
My Lord, my Lord, you've handled a lot of commercial cases. Some of us practice before you. And sometimes business interests do conflict with constitutional rights and other issues within our Constitution. For example, when foreign investment rules conflict with some of our local laws, there tend to be the tendency of the court to always, or sometimes, let me use for want of a better word, sometimes tend in favor of what some Ghanaians refer to as domestic or economic rights. For example, when foreign investment rules and local or domestic rules do clash, how do you manage that thin line to ensure that there is confidence from the investor community on our judiciary?
Thank you, Mr. Chairman. Our judgments are always based on the evidence before us and the law. First of all, the ground norm, the Constitution, whatever it says is the law. Two, if you can't get it from there, you go to case law or statute, and you go according to what they say. As a judge, you have the discretion to interpret, but you don't go outside the remits of the law. Mr. Chairman, that's it.
There is any further question? Yes, if you have a follow-up, please do.
My Lord, most of the agreements that we ratify in Parliament do have some arbitration provisions in there, but you realize that some of these investors do rush straight to the foreign courts or tribunals without exhausting local remedies, and many times the AGs have to go to London or some of the international tribunals to have some of these decisions reversed before it comes back to you. How would you advise on some of these things as a judge?
Thank you, Mr. Chairman. When unilaterals and multilateral companies are involved, you look at the contract they have signed. If there's an arbitration clause in it, they have to explore that first before coming to court. So as a judge, you look at the contract they themselves have signed. And if they have not exhausted all the grievance resolution clauses in there, you refer them back to it before they come to you. Thank you.
That's my second question. Very well. My Lord, in the past, you've called for the law school to teach. Thank you very much. My Lord, let me start again. You've called the law school to teach subjects like cybersecurity, intellectual property. Why is this so important, and how can we modernize our legal education without losing focus on fundamental legal principles? I know it's part of some of the issues that we've spoken about, having some of these specialized courses being taught at the law school.
Mr. Chairman, law is dynamic. And the life of the law is not static logic, but experience. Things are coming every day. A lot of things are evolving. You will be left behind if you don't follow the trend. So now cyber security and things are now issues of the moment. And it's just prudent that students coming out as lawyers are taught these things. So that is the reason. I don't remember if I got the question well that I suggested. I don't remember that, but even if I did, that's the reason behind it. We must be abreast with times, otherwise we are left behind. Thank you.
My Lord, this is my last question. Since you never walk alone, on your CV, you were chairman of the Koforidua Circuit Tribunal from 1996 to 2000. And Ghanaians recall the work of public tribunals. Because once you are invited there, it means Wahala don't come. And I know it's part of our constitution, public tribunals. Would you advocate for the setting up of public tribunals again to speed up or assist with the justice delivery program? Thank you.
Thank you, Mr. Chairman. I like the way you put it. That's exactly what I would do. But unfortunately, it's a wrong perception. People are more relaxed when they appear before the tribunals because, you know, the panel is 3, 2 ordinary people and the judge, who is a lawyer. They are more comfortable from my experience. Thank you.
My Lord, don't you think...
But you say that is your last question. Very well.
My Lord is enjoying the question. So relax, Chairman. My Lord, don't you think Justice Senyo Dzamefe sitting with 2 ordinary Ghanaians on a public tribunal will bully them with his law, Chairman, and direct them as to how to take certain decisions, especially when they are not legal practitioners or professionals in that vein? Thank you.
Thank you, Mr. Chairman. It's unfortunate we think, Mr. Chairman, I said once somewhere that law is 20%, wisdom is 80%. Don't underrate those people. They may not know the technical terms, but the wisdom in every case, they know, and you can't bully them. Thank you.
Thank you. I will proceed to give the floor to Honorable Jerry Ahmed Shaib.
Thank you very much, Honorable Chair. I appreciate the opportunity. My Lord, congratulations and you're welcome. Honorable Chair, if I have your permission, I just want to refer to the Constitution, Article 1461. That states that a justice of the Superior Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. My question is, what would constitute stated misbehavior for you? What are the acts or omissions? About 3 acts or omissions that for you would constitute stated misbehavior, and 3 acts or omissions that you think would not constitute stated misbehavior. Thank you.
Mr. Chairman,
Yes, my Lord, we realize that there is a pending matter on that issue before the courts. So you are sitting in your capacity as a nominee being vetted. you are not sitting here in a capacity as a Supreme Court judge. So I am inclined to humbly overrule the question.
Thank you, Mr. Chairman.
Chairman, with respect, the nominee hasn't made a specific reference to a particular case for, the questioner hasn't made reference to a specific case. I believe that if I understood you right, you are more or less relying on a sub judice principle to rule the question out of order. I humbly submit that to the extent that the nominee is here to express views on the Constitution and public policy matters, you allow him to answer. If we now box ourselves into this situation, then I'm afraid we may not be doing justice to the responsibility imposed on us by the Constitution this morning. He has not referred to a particular matter. And like I argued recently on the floor, the sub judice rule cannot be applied in absolute terms, that there is a matter related somewhere, so Parliament cannot move. He referred to the Constitution and said, what is your view? Give us 3 instances. That is not related to whatever matter you are referring to. In any event, you haven't shared with us the matter that you think, if the question is answered, it will create a problem for same. So I respectfully submit that you permit it.
Honorable members, we all know the matter, even if not expressly stated. He is a Supreme Court nominee before us. Who knows that when the matter, an aspect end up at the Supreme Court, you may be called upon to preside over it. So, honorable members, it is not proper that we solicit the opinion of a Supreme Court nominee before us on the question being asked. With all due respect, the question is overruled. I will give the floor to the member to ask another question.
Thank you very much, Honorable Chair. Honorable Chair, before asking the question, I just want to make reference to this. It's, with all due deference to you, it has nothing whatsoever for me to do with a pending matter that has to do with the Chief Justice, which you are making reference to. If you look at even the paraphrase, it goes on to say that removal of justices of superior courts and chairmen of regional tribunal. So, respectfully, it has nothing whatsoever to do with the stance you are taking now. Because I have asked that, what would constitute? He is going in as a justice of the superior court. And I'm asking in his view, what would constitute an act or omission that would amount to stated misbehavior?
Honorable member, you know the rules. After the ruling of the chairman or the speaker, we don't argue that. Please ask another question.
Very well. Just for purposes of record. My Lord, respectfully, would you consider Superior Court judges to have all, when they are supposed to have, as government appointees, they are supposed to file every indication of properties they have, and they do what we call the declaration of assets. Is it something that is it a position you would also consider for judges of the Supreme Court or judges as a whole to also have, as in, file their declaration of assets? And if yes, respectfully, why? And if no, why not? Thank you.
Mr. Chairman.
Honorable nominee. Please proceed to answer the question.
Mr. Chairman, as the Honorable said, if that is the law, that all appointees, government appointees, should declare their assets, and judges are government appointees, why not? They have to declare their assets. Thank you.
So is it the case that you have filed your assets declaration?
Yes, Mr. Chairman.
Very well. Honorable Chair, I also want to find out and whether we are considering technological impact on constitutional requirements. So it has to do with Article 68, I think to 9 requires that the Speaker to take presidential oath when acting for the President who is absent and Vice President, but not when the Vice President is acting alone. In an era of instant global communication, does this distinction remain constitutionally necessary? That should the absence from the Republic be redefined, so for instance, when the President is not in town, then we have the Vice President. And when the Vice President is also not in town, we have the Speaker. And we are asking, so in this current technological terms, and what about when all the three of them are out? What would be your position against this technological advancement?
So, Honorable Jerry Shai, what exactly is your question?
My question is that in this technological advancement stage, when all three are out, the President, Vice President, the Speaker, what would be your position? Do we have the Chief Justice acting?
Yes, Honorable Nominee.
Thank you, Mr. Chairman. Even though I'm not very clear with the question, I would say that from my long experience on the bench and from my own wisdom, I scarcely give views and opinions on issues because the view or opinion I'll give carries so much weight. I'm a judge. Who knows whether tomorrow this same issue will come before me? Then I'm expected to go by what I said. Meanwhile, the facts may not be on all fours. So as much as possible, I don't give views and opinions on things, on topical issues like this. Thank you, sir.
Thank you. Any other question?
Just a follow-up. My Lord, is it to say that when there are issues of general knowledge and you are being requested to make a statement on, you decline doing so just because whenever you make such, it carries weight, so it would mean something else?
No, Mr. Chairman. Currently, there's a situation on hand. Currently, there is somebody acting. So whatever I may say may be this way or that way, which I wouldn't want to do.
But, Honorable Chair, my question was specific, sorry. I made reference to technological advancement.
Honorable Member, you are entitled to a follow-up question. You have
yes,
asked
I'm
the
just trying to make,
question.
because
you have asked the follow-up question. Yes, Minority Leader.
Chairman, I want to help to situate the question correctly. My Lord, the gravamen of his question was to the effect that there's clarity on, in the absence of the President, Vice President acts. In the absence of the Vice President, the Speaker acts. And in fact, that has received judicial blessing, where the Speaker would even have to take the presidential oath. What he's asking is that in the absence of all these three, so for instance, recently, Mr. President was out of the jurisdiction on an ECOWAS assignment. Madam Vice President, Her Excellency, was on medical leave. Mr. Speaker was also on an official assignment outside of the jurisdiction where there was this constitutional lacuna. What he wants to know is whether in the situation like what I've mentioned, the Chief Justice would have to act or take the presidential oath as acting president. That's the point he wanted to put across.
Mr. Chairman,
Whether the Chief Justice or acting Chief Justice or the head of the judiciary.
This is peculiar.
Yeah.
Like you rightly said, if the president is not there, the vice will take the oath. If it's not there, then the speaker, and then it goes down to the Chief Justice. But unfortunately, during that period, there wasn't a substantive Chief Justice, but we have an acting Chief Justice. I don't think the law says that the acting Chief Justice should take an oath. Thank you.
So your answer will be different if there is a substantive Chief Justice.
Yes, ma'am.
And your view is that in that instance, the Chief Justice will have to take the presidential oath as acting president, correct?
Yes.
All right.
Yes, your last question.
Thank you very much, Honorable Chair. My Lord, respectfully, government recently has engaged in a deportation policy of foreigners who have been found to be illegally mining. And my question to you is that, does this violate Article 17 of the Equality Before the Law? And can citizenship status justify different legal treatment for identical criminal conduct?
Mr. Chairman, crime is a crime. Crime doesn't know who commits it. Once you've committed a crime, you must go as to what the law says. So if the law says that a foreigner has committed a crime and after conviction and sentence, they are to be deported, why not? Thank you.
Yes, a follow-up. But in these instances, there is no conviction and sentencing. But the fact that they have been arrested for having conducted themselves in that manner, they are deported. Would you suggest some recommendations?
Thank you, Mr. Chairman. I cannot tell what decision informed that, what reason informed that decision. So I'm not in a position now to say why they were deported. I think it was an executive or decision, so I cannot say why. Thank you.
Thank you very much, my Lord. I wish you all the best.
Thank you.
I will proceed to give the floor to Honorable Bahama Ayariga, the leader of government business.
My Lord, the nominee, Justice Senyo, congratulations on your nomination.
Thank you.
You've been around for a while. I remember recently, and even this morning, the arguments about the proper size of our Supreme Court, how many judges we should have appointed as Supreme Court judges, has been a raging political, legal issue. And even this morning, when you sat there, you were greeted with a statement by the minority leader on that matter. Let me ask, as a member of parliament representing a constituency at the furthest end of the country, that is Boku Central, and an individual seeking justice is entitled to litigate his case up to the Supreme Court by way of right to appeal up to the Supreme Court, depending on where he started the matter. Do you think it is fair that if I'm a citizen of Boku and I start my matter either in Boku or at the High Court in Bolga, I must always travel all the way to Accra to have access to justice at the Supreme Court. Have you thought about the need for a northern bench? Just as you now have a Court of Appeal in Kumasi, and I think you had even started a Court of Appeal in Tamale. I think it went on for a while. And Cape Coast. Have you thought about the need for a northern bench of the Supreme Court so that the people of the North do not always have to travel to Accra when they seek justice in the Supreme Court?
Thank you, Mr. Chairman. We have only one Supreme Court in Ghana, and that court can have several branches, but it's the same Supreme Court, just as the Court of Appeal and the High Courts. So I don't see anything wrong if there's a branch there.
So, to really be fair, maybe we should consider having a branch up north of the same court. Now, you are not opposed to a policy like that, even though you are not in a position to take that decision, but you are not opposed to a policy like that. That's what I gather from your response. As at now, what is the size in terms of the number of the judges in the Supreme Court? Do you recall? I won't hold you to it, but do you recall how many we have now? If you take out the 7 nominees that we have before us.
13, I guess, 13.
You have 13. In 2024, the Chief Justice wrote a letter to the President recommending that the average size of the court should be 20. The letter was made public, I think, by Asase Radio, so I'm sure a lot of people had the opportunity to see the letter. Asase Radio made the letter public. I have the report here, media report, in which Asase Radio has shared details of the letter requesting the appointment of the 5 judges, and then the letter included a detailed analysis justifying the need for these appointments. So beyond my argument about a northern bench of the court so that people in the north can have access to justice, the letter that the Chief Justice wrote compared Ghana to the US. I don't know if you saw the letter or at least read the media reportage and discussion of the letter. Because I want to take you through the details. I don't know if you saw the letter or you read the media reports. Just let me know that so that I can know what information to put out when doing the analysis.
Thank you, Mr. Chairman. I haven't cited the letter, but I heard a bit of it on social media.
Well, yeah, the Chief Justice argued, and I don't know if you agree with this argument. I just 3 arguments, and then I would end it there. One, Chief Justice says that there are delays in the administration of justice. Supreme Court judges are overburdened, and they have to write opinions, they have to hold conferences, and if you have less than 20 judges, it definitely affects the administration of justice at the level of the Supreme Court. Do you agree with that?
Mr. Chairman, I haven't cited the letter you are referring to, and I don't know the reasons given, but from what I heard from you, delays and that the judges are overburdened because of the caseload. The framers of our law, the Constitution, know why they haven't put a limit onto the number of Supreme Court judges. It's not capped. I keep saying that the law is always evolving. Maybe there's a reason. So far as the Constitution doesn't cap the number of judges, I am for it. Thank you.
The second argument that the Chief Justice makes is that we tend to compare ourselves with the U.S. and say the U.S. has a Supreme Court and they have only 9 judges. But the Chief Justice in the letter indicated that in actual fact, in the U.S., they have 50 Supreme Courts in the states, plus the one federal Supreme Court. And so you can't compare the Ghanaian situation where we have one Supreme Court versus the U.S. that has 50 Supreme Courts at the federal state, at the state level, joining the federal Supreme Court. Do you subscribe to that argument of the Chief Justice?
Yes, Mr. Chairman. See, in the states, every state has its Supreme Court. That is the state Supreme Courts. And then
there are 50 of them.
Yes, and then the Central Federal Court. And even on that, it's only constitutional and federal issues that go to the Federal Supreme Court. And then on top of that, they have the discretion to choose. Unlike here, they have the discretion to say that it's only on 6 cases we sit in the year. So they are not overburdened like we have here. So if the argument of in that letter you said says that due to delays and caseload, number of judges be increased, fine, I support it. But I guess that the flexibility is there for the evolving nature of the system, which there must be justification for every additional judge. Thank you.
Yeah, the CJ, in making a case for a minimum of 20 judges at the Supreme Court, indicated, for instance, and gave statistics, that in 2008 and 2019, in the U.S., the federal Supreme Court, the U.S. Supreme Court, the cases filed numbered 6,442. 6,442. But that year, the cases that were argued, out of the 6,442, the cases that were argued were 73 only. And indeed, the cases that were disposed were 69. So you have 6,442, and then you could only, they only dispose of 73, because they, like you said, they have a right to choose what cases to hear and what cases not to hear. But our Supreme Court, disposes, on the average, disposes of about 400 cases in a year, given, the pressure on them. And in spite of their numbers, would you say that in spite of the challenges, our judges really do well?
Yes, Mr. Chairman, I will say that they do very well. Our Supreme Court here has 3 main jurisdictions: original, appellate, and supervisory. And even chieftains' cases from the National House of Chiefs Appeals go to them. It's loaded, and it's virtually becoming a daily court. So I buy the argument that they are overloaded, and therefore there is a need to increase the numbers.
So in general, you agree with the argument that indeed we need to have more Supreme Court judges so that we can have cases expedited and people's right to have access to the Supreme Court vindicated.
Mr. Chairman, yes, I agree.
The last one, which is generally about the rule of law, You know that investor confidence is also moved by the extent to which a country has the rule of law entrenched. Economic performance is also based on levels of investments in your country. So there is a direct relationship between the rule of law, having access to justice, expedited justice, and economic development. There's a direct relationship, since rule of law is one key indicator that encourages foreign investments into the country. So do you say that if we have more judges and cases are held expeditiously, that the economy of Ghana will do better and all of us will benefit?
Mr. Chairman, that is true, because if within a short period your issues are resolved, why not? You have confidence in the system. But if it takes too much time, then you lose trust in the system. So I will always agree with you that the faster the cases go, the better for the investor community. And then there's trust in the system. And therefore, if the small numbers are going to delay cases, why not? Why don't you increase the numbers so that you... But that doesn't open the floodgates that you keep rolling out Supreme Court judges. Depending on the exigency and the justification, then the numbers can be increased, sir. Thank you.
But is it not inevitable that we're going to have more numbers because we are creating districts and each district is demanding a court, and we are creating new regions and each region is demanding, a court, a high court, and we are, graduating many lawyers into the system, and many more people are going to have access to justice, and the lawyers are going to be appealing. Is it not inevitable that the case load is definitely going to increase? In which case, the right to appeal and therefore the number of cases that will end in the Supreme Court will also increase whether you like it or not.
Thank you, Mr. Chairman. Once people are aware of their rights, they will definitely go to court. And like I said earlier, there must be more courts so that accessibility to justice is very easy. It's good if we have plenty courts and then the cases are spread thin and cases move faster. So I support your idea. The more courts we have, the better for us. Cases go faster. More lawyers are involved. More judges are involved. And the citizens are happy that their cases are heard early and disposed of very early. Cases delayed 10, 20 years, 15 years is not the best. If we have plenty courts and then within few months the cases are disposed of, why not? I am for it, Mr. Chairman. Thank you.
I'm asking this question basically because ultimately it is a burden on the taxpayer. Ultimately, because if we appoint additional judges, the taxpayer has to pay. And, as a nominee, you will have to make a case to the taxpayer why he should pay for your services as part of the considerations that as a committee we will be making. So you do agree that citizens ultimately will benefit if we have an adequately sized number of judges at the Supreme Court?
Mr. Chairman, nothing good in life comes without a cost. Yes, we have to weigh the pros and cons. Yes, I agree that more money will be spent on the judges and the courts, but then the benefit, quick disposal of cases, we weigh all and we go for the more courts to make the citizens and the investor community happy and have confidence and trust in the judiciary. Thank you.
Thank you, Chairman. I have no further questions.
Very well. I will then give the floor to Honorable Hajia Ladi Ayamba.
Thank you, Chairman. Let me first of all say congratulations, well done.
Thank you.
I looked through your CV and I realized that you are a basket of a lot of knowledge and good things in your own industry.
Thank you.
We have observed that in our justice system and justice delivery, many a times a lot of your work is delayed. A lot of your work is delayed. Someone could be in court for even 10 years. Not even only, not in your place, the superior, but even the lower courts. So there is this perception that justice delayed is justice denied. What is your view on that perception? And what will you suggest to be done to stop or at least to reduce the delayance in justice delivery? Thank you.
Thank you, Mr. Chairman. Some few minutes ago, I said we have to look at the tools we use. We have to go high technology now, AI. One of our main constraints is the recording process, writing longhand, and then the processes by themselves. A lot of people who don't know this always say cases delay unnecessarily. Yes, sometimes it does, but then the procedures too, we have to see to it that we shorten the procedures and the time limits. Then secondly, I talk about the tools. If we can go AI, I said that recordings are done swiftly. So that by
Hello, I'm Sweetie Aboshi. Welcome to Joy News today. I know we just interrupted the vetting process of the Supreme Court judges nominees facing the appointment committee. We'll get back there in a bit. But in this bulletin, our latest headlines for today, the Supreme Court nominee Justice Senyo Dzamefe proposes introduction of fixed timelines for the completion of court cases. Details as he appears before Parliament Appointments Committee today, and that is where we just broke from. And in other headlines today, bodies of drowned Laura students handed over to families for burial after recovery at Dikpe Bridge. We'll bring you some details on that, as well as our After the Flood series, where we'll tell you the story of a retiree who lost his 1.8 million Ghana cedis investment to the Akosomo Dam spillage. 2 years on, he's still picking up the pieces. These are our latest headlines for this afternoon, but let's take you back to Parliament Appointment Committee and follow the vetting processes.
To steal a bunch of plantain. An underage goes to steal some rice in a cooker and is eating. All these people, you collect them, you go and dump them, and sometimes even they are not segregated. The hardened, the non-hardened, all of them are together. What will you suggest to ensure that I will call these people, these little pilfering and what have you, they don't find themselves languishing, sometimes even years, sometimes forgotten, either in being called that they are in detention or they are whatsoever.
So, Honorable Haji Alade, what is the question?
My question is, what will you suggest to be done to those people so that we don't get them going into detention and wasting time?
Thank you, Mr. Chairman. Madam, you said we collect them and go and dump them. We don't do that. We try them, and if they are found guilty, they are convicted and sentenced.
Well, sorry, please, I'm not referring to the convicted ones. I'm referring to those that, for instance, you just say, oh, you have to go and come, every day go and come, and the place is choked. When the police cells are full, you remand. You send them to the prisons where maybe they are not even supposed to go. They are the ones I'm referring to, but not the convicted ones.
Thank you, Madam. We as judges interpret the law, the laws you make. If you change the laws, we interpret it accordingly. The prosecutors come to ask for remand because they have not finished with investigations. Madam, you can't ask the people to go home. You remand. But like you are saying, of course, it must be reasonable time. So until the laws are changed, there's nothing the judges can do, please. Thank you. So we are waiting for you to change the laws. Then, for example, the penal system, we are looking up to you. If you change it, fine. Thank you.